Good morning, ladies and gentlemen. I'm very pleased to be here. Thank you, Alan, for the invitation, and I'm also pleased to see many friends, colleagues, and the usual suspects of migration and human rights. You gave me as a title the question whether the compact is a game changer for international. So I will address this question from several angles, because of course there is no clear-cut answer. As a soft law instrument, clearly, in comparison with previous soft law instrument adopted by the UN on migration, the Global Compact for Migration constitutes the most comprehensive multilateral instrument specifically devoted to migration. The comprehensiveness of this intergovernmental instrument is obviously inherent in its very rational, because the very premise of the compact is to develop a comprehensive and all-encompassing approach based on the idea that UN member states have shared responsibilities to one another. And because they also acknowledge that there are all countries of origin, transit and destination. The main added value of the compact relies on its wide scope regarding both its addresses and thematic coverage. The Global Compact is not only addressed to states, as it is generally the case, but by contrast to previous UN initiatives, its scope is enlarged to non-state actors. The Compact extends most remarkably to migrants themselves, for once, local communities, civil society, private sector, trade union, and the media. So the addresses are quite broadly understood. And of course, the inclusive scope of the Compact is further reflected by its broad thematic coverage, which addresses a vast number of topical issues through the identification of 23 objectives. So the list of these 23 objectives is quite extensive, and the content of the related actions to achieve these commitments is specified in considerable details. But of course, the comprehensiveness of the compact entails two main qualifications. First, despite this quite extensive coverage, the 23 objectives are not exhaustive. Of course, this is well known, but there is nothing about internal displacement. There is no reference to migration for the purpose of education, trade, service, and investment. And the second qualification is the following one. When the compact is assessed as a whole, the general picture remains quite segmented and highlight a piecemeal approach. This has been already mentioned by several commentators, but the Global Compact reads as a laundry list of objectives. There is no priority, no clear-cut articulation between objectives. And clearly what is missing is an overall design that unifies this list of 23 objectives. From this angle, the Global Compact may be better appraised as a consolidated document that restates and refines the outcomes of the vast number of previous soft law instruments adopted during the last decades. And these explain in terms that none of the objectives is fundamentally new. There is nothing fundamentally new, and we can even argue that the content is relatively conservative. So, what is new is not necessarily about the content as such, but about the related actions and the action-oriented approach. Of course, the 23 objectives are by definition aspirational, but the related actions to realize them are much more detailed and specific than in many other non-binding instruments adopted by the UN in the field of migration. And interestingly, in contrast to many previous software instruments, the Compact also addressed a broad range of national measures to be taken by individual states. So not only international cooperation at the bilateral, regional and universal level, but there are many actions that are focusing on domestic legislation, on at the domestic plane, calling for the review and amendment of existing domestic legislation in line with the objective of the Compact. So this action-oriented approach is probably a major added value. But clearly, from the angle of public international law, the main added value of the Compact is not legal. It is political by nature, because the main achievement of the Compact is to sanction and crystallize the consensus of the international community on the most topical issues associated with migration. And here is probably the most important added value. The Compact paves the way for a counter-narrative to populist rhetoric through a balanced, consensual and inclusive approach. So clearly, from this angle, the Global Compact is not the end, but a new critical step of an ongoing process which is political by nature. It must be seen as a roadmap to frame the international agenda through three basic means: evidence-based information, that is clearly lacking in the current debate. Second, inclusive dialogue, that is supposed to include, as mentioned before, not only state but also migrants, civil society, private sectors, and rule of law. So from this angle, international law is obviously part of the picture, but it is not conceived as, it is conceived as one means among others towards a broad political end. The Global Compact reaffirms in clear and quite strong terms rule of law. And clearly, even if this is obvious for lawyers, in this area there is a need for restating the importance of the rule of law. I will quote, for example, one extract from the Global Compact. Respect for the rule of law, due process and access to justice are fundamental to all aspects of migration governance. So clearly, this is probably an important aspect to be developed further alongside the topic of this conference. More generally, in the preamble of the Compact, the Compact rests on the UN Charter, the Universal Declaration of Human Rights, the core international human rights conventions, as well as a broad listing of several other specific treaties. So the commitment of states to international law is restated many times in the Compact. Due respect for international law is reaffirmed 56 times across the whole document. So clearly, from this angle, the content is relatively consensual and agreeably conservative, but the major change is a clear-cut endorsement of the duties of states to respect for international law. And unfortunately, today, given the political toxic debate surrounding migration, this basic restatement is crucial as such. We get from the angle of the content of the Compact, besides restating the respect for international law, the Compact reinforces existing international legal norms to unveil the centrality of the rule of law. It does not create new rules. It simply restates some existing rules. typically the compact reaffirms the quite traditional balancing act of international migration law between the sovereign right of the state to determine the national migration policy and the obligation to respect, protect and fulfill the human rights of all migrants regardless of their migration status. So this balancing act is not fundamentally new, but restated in the compact. The most, and from the angle of international law, we can distinguish two types of existing norms that have been restated in the compact. The first set of international rules are directly addressed to govern migration control. And again, the content is not new, but restating such basic rules and their plain applicability in migration control is still important today. The most relevant rules that are already well acknowledged in international law includes, of course, the prohibition of arbitrary detention, even if we can regret the new formulation about detention of children, but at least we have a restatement of the prohibition of arbitrary detention with the right to effective remedy and so on and so on. The prohibition of collective expulsion is also restated and mentioned several times, and this is a crucial norm because the prohibition of collective expulsion is not only absolute but also does apply to all migrants, including undocumented ones. The principle of non-refoulement under human rights law, even if I suspect that diplomats were not aware about its real meaning, according to the discussion I had with some of them, but at least the principle of non-refoulement is clearly restated and in a relatively broad angle through the notion of irreparable harm. And of course, among other related norms of international law, the duty to prevent and penalize the smuggling of migrants, trafficking in persons, while avoiding criminalization of migrants who are smuggled or trafficked, due process guarantees, individual assessment and effective remedy, consular protection, and perhaps more importantly, the best interest of the child. That is restated on many posts the old documents. So this body of legal norms is significant, but states were not ready to go beyond this restatement. Several important issues related to undocumented migration have been watered down in the final version, regarding the firewall, regarding non-criminalization of migrants, detention of children, and so on. And also, Objective 5 devoted to regular migration clearly does not break new ground, but it can open, it can develop further, because clearly Objective 5 has the potential to frame the international agenda in the future. But in its current state, this is simply too vague to have some legal significance. The second set, besides the norms of international law governing migration control, the second set of legally binding rules focuses on the human rights of migrants during their stay in the state territory. And they refer to many crucial rules. Elimination, of course, of all forms of discrimination, fight against racism, prohibition of slavery and forced labor, access to basic services regardless migration status, access to social security, portability of social security are quite important, especially for migrant workers, and also equal treatment with nationals with regard to labor rights. Of course, all these norms are well known, they are not fundamentally new, but the very fact that states have restated their importance is crucial in the current political context. So to conclude, the main virtue of the compact is essentially political. It is intended to provide a new impetus for multilateralism as a counter-system to populism. It lays down the ground for a new narrative of migration based on dialogue, trust and responsibility. These are the key words stated several times in the compact. Of course, the legal relevance of the compact remains limited to some extent, but its adoption represents an achievement on its own in the current political context. After a long and quite tortuous process of maturation, migration is eventually endorsed as a matter of international cooperation on its own. And clearly the use of soft instruments has been instrumental in fostering interstate dialogue and confidence building on a relatively divisive issue traditionally associated with state sovereignty. Migration is now acknowledged as a question of shared responsibilities, which call for a global approach. And with the compact, the UN and its member states have now a common framework to shape their future actions in line with a broad range of commitments. It is of course premature to assess whether the compact will deliver its promise for a more balanced and integrated approach to migrants' rights, but clearly the compact has the potential to improve the lives of migrants and the cooperation among states, but whether that potential is realized will largely depend on the application by states. Thank you very much.